Hi, class, and welcome back to yet another episode of Intellectual Property. Today, we're going to begin our discussion of copyright law, the most fun part of intellectual property law, or at least one of the most fun parts in my opinion. So I'm really looking forward to this. Today, we're going to be looking at copyrightable subject matter, specifically, what is it specifically that copyright actually protects? In other words, what's the subject matter of copyright protection? How do we identify what it is that copyright is actually created to protect? So as with patent law, which we've been discussing, the authority to create copyright law is given to Congress by the Constitution, specifically by the intellectual property clause, right? So copyright initially was conceptualized as a way of Congress promoting the progress of science, by which the drafters of the Constitution meant knowledge, right? By securing to limited times to authors the exclusive right to their respective writings, right? So the idea behind copyright protection was that Congress was authorized by the Constitution to promote the generation of knowledge by giving the authors of works of authorship certain exclusive rights to reproduce those works of authorship for a limited period of time, right? So, in other words, under the Copyright Act, under the initial kind of conception of the Copyright Act, the initial conception of what copyright would exist for, and what Congress actually did when it exercised that power in 1790 by creating the initial Copyright Act, was to give authors of works of authorship certain exclusive rights to use those works. Now, the kinds of works of authorship covered by copyright have expanded dramatically over time, and so has the duration of copyright protection, as well as the rights that we give those authors, right? So the history of copyright doctrine is a history of expansion, right? It's a history of copyright, covering more things, providing more rights, and lasting for a longer period of time. But the core concept has always remained the same. So today we can kind of identify 5 exclusive rights that sort of characterize the kinds of things that we give copyright owners exclusive rights in, as what we want to call the property right nature of copyright protection, to the extent we want to conceptualize copyright as a form of property right, that is. So reproduction, adaptation, distribution, and then public performance and display. What's reproduction? Well, it's kind of the kind of core thing we think about as copyright accomplishing, namely the exclusive right to create copies of the work of authorship, right? And this really goes to sort of where copyright came from in the first place. After all, the sort of proto concept of copyright was actually generated by the Stationers Company in roughly 16th century England in response to the introduction of the printing press, right? Prior to the printing press, books, the sort of classic work of authorship, were only reproducible in manuscript form. There was no need for copyright protection because the expensive part of producing a book wasn't writing the book, it was making each handwritten copy of the book. Right? So the transactions costs associated with the production of copies of works of authorship was actually in the copying, not the generation of the text itself, at least not primarily in the generation of the text. Now, when the printing press was introduced, all of a sudden, the marginal cost of producing new copies went way down. So all of a sudden, the exclusive right to reproduce copies of a book became something valuable when it hadn't been valuable before. So copyright was in effect created by the Stationers Company, a guild, or we might call it something like a cartel today, in order to ensure that that the producers, the publishers of books, could maintain exclusivity over the books that they were reproducing. In other words, a way of kind of parceling out the right to create reproductions of different books in order, in effect, to maximize the profit margins of publishers. Okay, now that was codified by the English, by the Crown, basically, in the Statute of Anne, right, which created the first copyright that vested in authors rather than in publishers, although in practice, under the Statute of Anne, authors typically transferred their copyright ownership to the publishers, who then utilized that copyright ownership in order to reproduce works of authorship. So that the kind of the end game was still the same, even though authors arguably had more rights to assert in the front end, and in some cases might hang on to copyright protection if they were sufficiently wealthy to reproduce their own books, for example. But typically they transfer those rights to publishers anyway, right? So the Statute of Anne eventually became the basis for what became the initial United States Copyright Act. So we essentially imported English copyright law to the United States with the unique distinction, however, of course, that for quite some time in the 18th and early 19th century United States, copyright protection only went to American authors, right? So even though we imported English law and codified it into United States law, we didn't extend copyright protection to English authors. So a lot of the initial publishing in the United States of books and so on were actually foreign books that were reproduced in the United States without paying any royalties, right? Basically, this was a way of importing as much literature as possible, especially because not that much literature was being produced in the United States at the time. Now, subsequently, as different kinds or different media, different categories of works of authorship became reproducible over time, those different categories of works were also incorporated within the scope of copyright ownership. So pretty early on, right, music was something that could be reproduced and ultimately could be printed as well. And so music was incorporated within the scope of copyright protection. That is, transcriptions of musical works. Later, as photography was invented, photography was incorporated within the scope of copyright protection, as were other forms of pictorial works, as they gradually could be more and more efficiently reproduced, as well as other kinds of works like maps and charts and so on were incorporated within the scope of copyright protection early on. Later, as the capacity to record and reproduce sound became possible, that too was incorporated within the scope of copyright protection, as well as motion pictures, right? So gradually, as new technologies enabled the capture and reproduction of new categories of works that hadn't previously been able to be captured or to be reproduced, copyright was malleable, copyright was flexible, and it incorporated all of these new categories, giving them different kinds of rights depending on the nature of the work. So the right of reproduction, the right to create copies, the right of adaptation, right, which is the right to use elements of a copyrighted work of authorship to create a new copyrighted work of authorship that incorporates elements from a previously existing work, right? The right of distribution, which is essentially the right to provide copies to the public, tied to the right to make those copies in the first place, right? So in many cases, the right of reproduction would be kind of meaningless on its own if it'd be difficult to actually police. The right of distribution ensures that copyright owners can look to those who are both reproducing the works and distributing them to the public, typically for money, and prevent them from doing that without permission, right? So it's in effect the right to police the market for a work of authorship. And then the right of public performance and public display are the exclusive rights to present the work in a public context, and by extension, the exclusive right to generate a revenue from the presentation of those works in question. And of course, there are many limitations or exclusions to all of these exclusive rights, which we'll talk about later in the class. But broadly speaking, those are the exclusive rights that copyright gives to copyright owners. Now, why do we have copyright protection in the first place? Well, as with patent protection, the sort of prevailing view or prevailing theory of copyright protection is that it's a means to an end, right? The idea behind copyright protection is that by granting copyright protection, we encourage the production of works of authorship, which the public values, and that if we didn't have copyright protection, we would under-incentivize the production of works of authorship. We'd have market failures in works of authorship. It would be inefficient, and the public would go wanting for the works of authorship that it wants to consume. Therefore, we give exclusive rights in works of authorship to authors in order to encourage them to produce the works of authorship the public wants to consume. And the at least theoretical bargain is that this is kind of a quid pro quo. The public gives something in order to get something in return. It gives copyright protection in exchange for works of authorship. And at least in theory, the value of the works of authorship to the public are larger than the cost of giving copyright protection. And as a consequence, the public has a net benefit as a consequence of copyright protection. Now, of course, this consequentialist story is at least theoretically an empirical one, which we at least theoretically could test, although we don't seem to actually do that in practice. And notably, it has the implication that if copyright is justified because it produces good outcomes, then it necessarily follows that to the extent copyright doesn't produce good outcomes, it must not be justified. In other words, if the bargain is bad, then copyright is no longer justified under this theory. Now, in relation to copyright protection, of course, the deontological or natural or moral rights theories of protection play an even larger role than they do in other forms of intellectual property protection, specifically because the public in general has kind of moral heuristics attached to authorship that are deeper and more intense in a lot of ways than the kinds of moral heuristics than they have even attaching to inventorship. Sorry, inventors, but I think it's fair to say that, right? I mean, we tend to think that authors of works of authorship are engaging in socially beneficial, meaningful activity, and therefore are entitled to certain kinds of control over the works of authorship that they create, either because we admire them for their expressivity or because we think that the works that they're producing are an expression of themselves or of their personality, and therefore they're kind of entitled to exert control over how other people use, consume, distribute, and talk about those works, in arguably to a greater degree than we would with respect to inventions and discoveries, which are ultimately functional and intended, intended to accomplish a goal independent of the invention or discovery itself. And the works of authorship kind of exist and make their own purpose, as it were. And we typically tend to think that as a consequence, they're morally laden, sort of, in a way that other forms of intellectual property maybe aren't. Now, at least in theory, right? At least in theory, the constitutional justification for copyright protection is consequentialist, right? I mean, recall the Constitution says that Congress can create copyright protection in order to promote the progress of science. That is to say, copyright is a means to an end, not an end in and of itself. But as a practical matter, the kind of shadow justification for copyright protection is probably largely deontological, right? People's moral intuitions are really tied to this idea that copyright is meaningful and that authorship is meaningful and that we should care about protecting authorship because of that meaning, not just because it produces good outcomes. But in any case, keep these theories of copyright in the back of your head as we read the different cases that kind of expound upon copyright doctrine, and ask yourself sort of, why are the courts getting to the outcomes that they're reaching? And are the decisions truly informed by consequentialist, utilitarian, or economic justifications? Or do you see the seeds of kind of moral heuristics embedded in the decision-making process? Okay, so in any case, subject matter of copyright extends to any original work of authorship fixed in any tangible medium of expression. So the two key elements: original works of authorship fixed in a tangible medium of expression. And of course, Section 102 of the Copyright Act gives a list of categories of works of authorship that are protected as a kind of non, at least theoretically, statutorily, as a kind of non-exclusive list. Now, in practice, works don't fit into any of these categories, typically are seen as not being protected. So even though the statute says works of authorship include the categories, as a practical matter, if you can't fit something into one of the categories, you're going to have a hard time claiming copyright protection. And luckily, the categories are really broad and they're interpreted super broadly, right? So literary works includes anything that consists of symbols in an order, right? That's a literary work, right? So a computer program, totally a literary work. It's symbols in an order. That's literary. It doesn't matter. No one would read it as literature. That it's a group of symbols intended to tell a computer to do something. Still literary work because it satisfies the formal criteria for being literary. Musical work, right? Any kind of composition, it's a musical work, right? Sound recording, any kind of sound recording or count. Same with motion pictures, pictorial, graphic, and sculptural works, and so on. So the categories are really broad, but you do want to try to fit the work in question into one of the categories or more in order to ensure that it can get protection. And this is another important point, right? I mean, these categories are non-exclusive when it comes to any particular work, right? So a work could fall into multiple categories. Like, for example, a song, right? A song is a musical work to the extent that it is a composition. It's also a sound recording to the extent that it's recorded and to the extent that a performance of the song is recorded. But it also might be a literary work to the extent that it has lyrics, right? The lyrics are going to be a literary element, right? So you can have lots of different elements embedded into one work. They can kind of cross categories, as it were. Okay, so let's think then about the first part of the subject matter of copyright, right? Originality and fixation, the two core elements of copyright protection. What do you have to do in order to get a copyright? This is a question I always love to ask. The answer is nothing but create a work and fix it in a tangible medium. Nothing other than create a tangible copy of the work in question. Right, that's all all it takes to create to get copyright protection. A lot of people think you have to file something with the government or with the Copyright Office in order to get a copyright. That's just not true, right? The Copyright Office registers works of authorship for copyright protection, but it doesn't grant copyrights. Copyright springs into existence the moment that you create a work of authorship in a fixed form, right? In other words, as soon as you write something down, as soon as you take a photograph or make a movie, it's protected by copyright the moment you create it, automatically, right? Automatically protected by copyright. The other thing to remember is that copyright protects the intangible work of authorship, not the tangible object in which it's fixed, right? In other words, if I write a book, right, my copyright goes to the words in a particular order, not to the physical book itself, right? Likewise, if I take a photograph, at least in theory, copyright protection goes to the intangible work of authorship embodied in the photograph rather than the physical copy of the photograph itself, whatever that means. And we'll try to talk and figure out, what it means to differentiate between the intangible work of authorship and the tangible copy later. It can be pretty tough in relation to some categories of works. Works relatively well when it comes to literary works like books. It's a lot harder to disaggregate the tangible and the intangible work from the tangible copy when it comes to something like PGS works, right? Where it's sort of like a smile without a cap, as it were. Okay, so fixation, really any kind of copy of a work of authorship will do, so long as it exists for more than a transitory period, right? So as a general rule, if you create something and it can be perceived from what it is that you've created, that's totally fine, right? Some forms of fixation are just so fleeting that courts have said that doesn't count as a fixation. In particular, like the transitory fixation of a digital work in a RAM chip in a computer under some circumstances as held to be insufficient duration to count as fixation. But as a general rule, if you can point to any copy of any kind, that's enough for fixation, right? So if I were talking in a room and I wasn't being recorded, not fixed, right? Because there's no recording, I can't play it back. But because I'm being recorded while I give this lecture, it's fixed and it's protected by copyright, right? So the talk that I'm giving, ad-libbing here for you, that's copyright protected simply by virtue of the fact that I'm creating on the fly, right? It isn't written down, it's not copied from anywhere, and it's being fixed in the tangible medium of an audio-visual work. Okay, the other core element is originality. And what do we mean by originality? Well, originality has two elements. A work of authorship is original only if it is not copied and contains some minimal degree of creativity. Okay, so we can talk about what that means in the context of the Bleistein case. This is a really important, relatively early copyright case from 1903 in a characteristically pithy opinion written by Justice Holmes. What happened in Bleistein? Right, well, we had a circus that started off in New York State, where they commissioned a bunch of really nice posters. You can see a version of the posters for the Wallace Circus here, like full color, nicely lithographed, beautiful posters that they were using to advertise for the circus. They were traveling around the country, and they actually ended up in southern Ohio, northern Kentucky area, and it seems like the circus wasn't doing so well. Right? They were kind of in financial straits, and they'd run out of advertising posters. So they went to a local company and said, hey, we need to get some new posters, but we're kind of low on cash. Can you make us copies of these ones that we've got? Oh, and by the way, make them a little smaller maybe and do it in black and white so it doesn't cost quite so much. Right? So they got copies of these posters made, and when the original company found out, oh, they were mad, right? They said, look, we created these posters. We registered these posters for copyright protection. We're the copyright owners of the posters. And you circus, you're not allowed to reproduce them without our permission, right? You have to ask us. We have the exclusive right to reproduce copies of this poster. If you want to reproduce it, you have to ask us, or in reality, you have to come to us, right? We're the copyright owner. If you want more copies, you have to come to us to get those copies reproduced. You can't just take them somewhere else and have somebody do them for cheaper for you. Okay. So they bring a copyright infringement action against the other printing company that's making these copies without permission. What's the defense? Well, the printing company says, hey, circus posters, advertisements aren't the kind of thing that copyright is intended to protect. Copyright is for protecting works of art. It's protecting works of science. It's for protecting things that add value to the world. It's not for protecting advertisements. And the Supreme Court 100% disagreed, right? In his opinion, Justice Holmes is best known for saying it's not the business of courts to judge the value of works of authorship for the purpose of copyright protection. Copyright protection extends to everything that satisfies the formal criteria for copyright protection, no matter what we think of the value of the work in question from a cultural sense, right? This is often known as the aesthetic non-discrimination doctrine. In other words, courts aren't supposed to aesthetically discriminate between different works in terms of determining whether or not those works are qualified for copyright protection. Essentially, the court says, look, if people like something, if people want to consume something, that's enough to consider it valuable. It doesn't matter what we think of it from a kind of broader cultural perspective, right? All that matters is the fact that it satisfies the basic criteria. Now, very interesting dissent from Justice Harlan in this case, pointing out that from a practical perspective, there's really no need to extend copyright protection to advertisements, right? After all, the company was paid to make this poster, right? They didn't create it because they wanted to, claim the future value. They created the poster because the circus paid them to create the poster. And if, they wanted to charge more, they could have charged more, right? But we don't need an incentive to encourage people to produce advertising. Essentially, Harlan's point was, look, people will create advertising. People will create this category of works of authorship, whether or not we incentivize it. So there's absolutely no reason to extend a copyright incentive to this category of works. To the extent we think copyright is justified because it encourages authors to create works of authorship, well, we don't need it here. It's not doing any work. Right? So interesting debate as to how we think about the theoretical justification for copyright protection and whether it's consistent with extending copyright protection in this context. In other words, should we be aesthetically non-discriminatory? Or maybe we should think about this differently and say copyright protection should only extend to works that actually need copyright protection in order to encourage the authors to create them in the first place. Okay, so let's continue. In addition, there are limitations on the scope of copyright protection, some of which we'll talk about today, some of which we'll talk about more extensively in our next class. One core limitation is the idea-expression dichotomy. In other words, copyright protects particular expressions of ideas, but it can't protect those ideas themselves. It's kind of like the Section 101 of copyright protection, Section 101 from the Patent Act. You might think of the idea-expression dichotomy in the same way. In other words, if something is too abstract, not sufficiently particularized, if an element of a work is too abstract and not sufficiently particularized, it can't become the subject of copyright protection. Copyright only extends to the original and particular expressions that are created by the author and embodied in a particular work of authorship. And that limitation is extended to all kinds of other things, including facts, right? So facts also can't be the subject of copyright protection, at least not individually, right? But they might potentially be the subject of copyright protection in the context of a compilation, right? So if you put enough facts together in a original order or original combination, then that order or combination might be the subject of copyright protection. And that's the subject of a really important Supreme Court case called Feist v. Rural, right? So this is the Supreme Court's real attempt to wrestle with the kind of ontology of the subject matter of copyright. In other words, what is it exactly that copyright protects, and what does it mean to talk about an original element of a work of authorship? So what happened in this case? Well, we have the Rural Telephone Service Corporate Company. Here we have this is a manual from the Rural Telephone Service Company. I also have some other swag from them, including a pen. You can see here, Rural Telephone Service Company, and a pen. Rural Telephone Service Company. And you can see there, I also have a playing card with their logo on it. Anyway, so Rural Telephone Service Company, a telephone service provider in rural Kansas, which, pursuant to its monopoly over the provision of telephone service in that particular area, also produces a phone book. Right? And that phone book, as does every other phone book, consists of white pages and yellow pages, right? The white pages list all of rural subscribers in alphabetical order, along with their phone number, and also includes, in many cases, an address for that subscriber. The yellow pages, by contrast, are advertising, where businesses can pay for yellow pages listings in order to advertise their services to the recipients of the phone book, who are Rural Telephone Service Company's subscribers. Okay, so Rural gives a copy of this phone book for free to all of its subscribers. It pays for the production of the phone book, but it generates revenue by selling advertising in the yellow pages. And, back in the day, this is a very profitable business, right? I mean, people use the telephone book all the time to figure out who is offering different kinds of services. This is a really important form of advertising, and the telephone companies generated a lot of revenue that way. Okay, so bring into the picture Feist Publishing. What does Feist do? Well, Feist is in the business of publishing telephone books. Now, you wouldn't think this would be a great business, right? The telephone companies give away telephone books for free. But what Feist does is it produces telephone books that are more useful than the telephone books that are produced by local companies. So it looks for telephone companies like rural that are really small and not serving that many subscribers, and therefore not producing telephone books that are all that useful, right? Because people are going to want to look for services provided by other companies that are outside of rural service area. They're going to call people who are outside of rural service area as well. So what Feist does is it produces its own telephone books that cover a larger area, right? It combines a whole bunch of phone books into one, produces a more desirable telephone book, which has the added advantage of being more desirable to advertise in, right? So basically, Feist is in the business of competing with local telephone companies for Yellow Pages ad revenue. And normally what it does is it just licenses the listings from the different phone companies and pays them for the right to use those listings. But it needs all of them, right? I mean, in order for its phone books to work, in order for them to be valuable to consumers, they need to be comprehensive. Well, what's the problem here? Feist goes to rural and says, hey, we want to license your telephone listings. And rural says, no, we're not going to give you permission. We don't want you to do it. So Feist is up a creek, and they just go ahead and do it anyway, right? They take the rural phone book, they copy the names and numbers out of the rural phone book, and they go ahead and create their telephone book anyway. Well, how does rural find out? Well, rural has done something very clever. Rural has inserted into its telephone book a number of fake listings for people who don't exist, right? So Feist's initial defense is, of course, wow, we didn't copy anything. We just went out and figured all this stuff out on our own. This is just facts. We weren't copying. You know, how can you prove it? And rural says, we can prove it because you copied the fake listings. You couldn't have found those fake listings by going out and figuring out who the subscribers were and getting their names and phone numbers, because those people don't exist, right? Those people don't exist at all. We made them up, and therefore we can point to those listings to prove that you copied our phone book rather than gathering the information on your own. So they bring a copyright infringement action against Feist for copying rural's white pages without permission. What's Feist's defense? Well, first thing Feist says is, look, telephone listings are just facts, right? Copyright can't protect facts because facts are just copied from the world, right? An element of a work of authorship has to be original in order to be protected by copyright. And a fact about the world isn't original because you, in a sense, copied it from the world, right? What does originality mean? Primarily, it means not copied, right? Well, Feist's defense is telephone listings are copied from the world. This is true. It's a fact about the world. You copied it. You put it in your phone book. Therefore, it's not protected by copyright. And the Supreme Court agreed with that, right? The Supreme Court adopted this line of reasoning and said the listings themselves, each individual listing is factual. Ergo, it's copied from the world. Ergo, it's not original and can't be protected by copyright. Now, of course, there's a couple analytical problems there, among them the fact that some of the listings were not copied from the world at all because, of course, they were fake, right? Another being that some of the listings were presumably not factual because, say, people died or they moved or their number changed or whatever, right? Those are not facts about the world anymore. They might have once been facts, but now they're not facts. Presumably, some of the listings could have been incorrect, right? In which case, they would also not be facts about the world. They would be false facts, I guess. They would be wrong. They wouldn't be copied because they're not real. Moreover, how do you think people get phone numbers in the first place, right? I mean, it's not like rural copies their phone numbers from some directory in the sky. Rural assigns the damn numbers to people, right? So they're not really facts about the world until rural makes them facts. So in some sense, rural isn't copying them from anywhere. Rural's making it true, right? So the logic's a little tortured, but nonetheless, Supreme Court says individual telephone listings, not copyrightable because they're facts. Because they're facts, they're copied, and things that are copied aren't original and therefore can't be protected. But it doesn't end there, right? Rural says, look, even if the individual listings can't be protected, the entire directory can be protected, right? Because we're not just protecting individual listings, we're protecting all. We want to protect all of the listings put together. Supreme Court says, well, yeah, that's true. right? A compilation of facts might be protectable insofar as the order, selection, or arrangement of those facts is sufficiently original to qualify for copyright protection. But according to the Supreme Court, originality has another element, right? There has to be a modicum of creativity, right? So not only does the work have to include an element that is original in the sense of independently created by the author of the work, i.e., not copied from the world or copied from some other work, right? That element that would qualify the work for copyright protection also has to have sufficient creativity to pass this minimal test. Now, the Supreme Court, goes on and on about how minimal the requirement of creativity is. That's a modicum of creativity, only the tiniest bit, only just enough to show that the work passes this minimal bar. But it says there has to be some, and a white pages telephone book just doesn't qualify, right? A white pages telephone directory has no creativity whatsoever from the Supreme Court's perspective. Whatever it is that creativity seems to mean, the Supreme Court does not do much of a job of telling us what it thinks creativity actually constitutes. Nonetheless, we are informed that whatever creativity is, there is no creativity whatsoever in a white pages telephone directory, and therefore the white pages directory cannot be a copyrighted work of authorship because it lacks any original element that could be protected by copyright. What would the element be here? Well, the element, at least in theory, would be the selection, ordering, and arrangement of the names and telephone numbers in the book. So ironically, right, although in Feist v. Rural, the court purports to be raising the bar for copyright protection by saying that copyright originality requires at least some modicum of originality. In practice, it seems like it's almost destroying the bar, because after reading Feist v. Rural, it's pretty hard to see how anything other than the white pages of the phone book isn't sufficiently original, isn't sufficiently creative to qualify for copyright protection. And we'll talk about that question a little bit more in class. I thought I'd leave you with a brief video for your amusement, illustrating the importance of the telephone book.
Thank you. Well, I wish I could get that excited about what? Nothing! Are you kidding? Page 73! Johnson! Maven! R! I'm somebody now! Millions of people look at this book every day! This is the kind of spontaneous publicity! Your name is print that makes people! I'm in print! Things are going to start happening to me now.